Hi, ladies and gentlemen. We are back with the CPIP Business Talks. I'm very happy to talk today about a topic I would say which is not as often as necessary discussed in public, and that is litigation of trade secrets. Trade secrets become more and more important, and the question what courts really expect when it comes to showing that a trade secret was really a trade secret, that is a fascinating topic. And before we start, I would like to remind you, for the ones who are new in this show, this is a live show. That means we are on LinkedIn, and you have a chat. And in that chat, you can write comments or questions. And then I can bring it here in the show and discuss that with my guest. And my guest today is Dr. Axel Oldekop. And he's really an expert in that field, and I'm happy that he is here. Axel, first of all, thank you very much for taking the time with us to to discuss with us this important topic. What I would like to ask you first is, how did you came into this strange field of IP?
Well, first of all, hello, Alexander, and then thanks for having me. And yeah, very good and very good question. I would say by chance, as it happens so often to IP litigators. To make a long story short, after school, I was torn between studying arts or law. And I decided on law, and during my university studies, I tried to come to circle by focusing on intellectual property law, because this included or includes copyright. Well, and then during writing my doctoral thesis, which was a one on copyright actually, I worked with a patent attorney, and I did trademark stuff. So, and then once you're working with a patent attorney, you come across patent law, of course. And from patent law, the step to trade secrets is not that far anymore, because you're dealing with technical issues. And I found that it's fun, and I liked it a lot. So I left the copyright business, and I started and I did patent law and trade secret law. So, and this was the way I came across IP in general, and technical fields of IP protection in particular. And well, after all, after now more than 20 years in practicing, I would say that I'm kind of jack of all trades, but master of none in IP issues.
Got you, got you. Yeah, this is fascinating how big that topic is, and how many niches are there. And yeah, as I said, these trade secret issues, I'm absolutely, it's great, and I'm very happy that you are on the Dplex here with your page, which is about how to define a trade secret and legal options and trade secrets in legally compliant manner. So all these content is available and very relevant for the audience. And there is also a podcast episode with you, where we try to explain these interplay of litigation and protection of trade secrets. And for the German-speaking audience, there is a wonderful book, Geschäftsgeheimnisse, Trade Secrets. And you mentioned that you had a tour for the last months, and you
Yeah.
have the next revision of the book.
Yeah. Well, yeah, actually, the next revision is due next year. I hope, or I'm afraid, however you would take it. But I just finished writing part in a commentary on yeah trade secret protection as well. So another book.
Here comes the next revision.
Here comes the next one. Yeah. So
Okay,
I'm glad that I reached in the manuscript to the publisher this weekend.
Okay, great.
Last weekend.
So a huge relief when it's done, right?
Yeah, free again. Yeah, absolutely.
Okay, let's start with the elephant in the room. Everybody knows that, and everybody asks that, and typically we get I guess, let's say, not that clear answers in because we have these fuzzy legal terms of adequate and appropriate and so on. So at the end of the day, when I try to find out what do I have to do to be sure that the judge says yes, that are adequate means or measures which you use to protect your trade secret. So shade a light into that fuzzy field. So what exactly is appropriate? What is necessary? What is adequate?
Well, of course, I can give you now the typical lawyer's answer. It depends, and in fact, it does. But to give some more flesh on the bone to the bones. So what we experience is that there's not yet a standard developed by the case law. So one fits all answer to this question: what is a good trade secret, or what are the requirements on a factual basis you have to meet to win the case in court. But I would say, from the experience that we had in the last years since the new law came into force, is that at least the civil courts are, I dare saying, quite generous, knowing that it is difficult for the trade secret owners to present the absolutely unsurmountable protection of their know-how, and so they as I said, they kind of generous, and I experienced that basically if you meet three requirements or three prongs, then you have a good case. So this is in particular, and this was stressed by some judgments expressively, that you need to establish this need to know principle in your entity, that make sure that only those guys who are actually dealing with this specific information have access, and not everybody in your company. And the second one is, it is always good to have at least some technical protection measures, and this doesn't have to be some magical stuff and on the best technical level available, but have some, for example, make sure that there's a login requirement to the database, or to your network, to your internet, or whatever. And the third thing is, which is also very helpful if you can establish that, is have some confidentiality clauses in your employees' contracts, or in the contracts with your suppliers or commercial customers at hand, and have them implemented. And
just to make that sure. So typically, when you run a 360 file server from Microsoft or other file data systems, they have a login, so you need a password to use it. And then typically with your password, there are certain rights, so access rights to certain files, and you can adjust to files. You can adjust the question who is allowed to get access to this file with which with which password. So is that something which is adequate?
Yeah. Yes, I would certainly say so. That if you make sure that, for example, the research and development team only have access to specific technical information on on the process that is used, or on the material that is implemented, whatever, then is something that is very convincing. Absolutely.
Okay. And ideally, I would assume there is a document anywhere in a drawer where is explained or documented which kind of employee, um, according to the role, according to the department, has which level of access. And so what is the access policy behind these passwords and the login efforts which you give to the users of the file system?
Yeah, well, of course. I mean, if you have a document, this is really a good case and good example. I mean, we lawyers, we love to have a document that you can present to the court. But in fact, we also had cases where you merely had a witness. You know, the guy responsible for the network, and who can either give an affidavit when it comes to proving that it is an information that needs procedural measures to keep it secret during the proceedings. Then you have to, you don't have to present full-fledged evidence, but an affidavit would be sufficient to reach this level. And later on, you can name them this person as a witness, and in fact, I've never actually had the case where it was contested, and that this guy had to be called into the stand and to give a oral testimony on this question, because it was not disputed.
Yeah. Okay, got you. So that is a structure. So then there is I have heard about a recommendation to document the access. So not in general, so to speak, so that in general somebody has access, but de facto R&D employee XY was on December 2nd, 2025, 12:14 CET, had access to this or that file and changed it or downloaded it or whatever.
Yeah.
Is this also necessary?
I think it's very important, and not only for proving that you have adequate protection measures in place, but to prove the appropriation. I mean, you have to show to the court that the defendant, the opponent, had somehow had access to it and copied it and whatever. And if you cannot prove it by analyzing an infringing embodiment, for example, then it is always very helpful if you have log files or something like that, where you can, as you just explained, where you can show in detail Mr. X had access to file Y on day Z.
Yeah, got you. Okay. So this is not the establishment of the trade secret. This is the question that you accuse somebody of
misappropriation. Yes, indeed.
Misappropriation. Yeah. Okay, got you. So now, when I talk with companies and we talk about trade secrets, so then sometimes I have the feeling the idea is to them just I'm don't saying somebody something and that's it. Yeah, so it's not public, so to speak, and that establishes already a trade secret. So when you are in court, I'm assume that this is not enough. So what is how can we distinguish, or is there a kind of guideline or recommendation for the practitioners out there to distinguish a real trade secret, so to speak, compared to some alleged trade secret, but which can be instantly disqualified that this is not?
Okay, so this is a good one. Let me just make one remark before I answer your question. You touched a very important point when you said that, okay, some companies still believe that it is sufficient to not publishing an information, and in fact it is not sufficient just to keep it secret. On a factual basis, and since we have the new law in force since April 2019, it is required to present adequate secrecy measures. So different to the previous situation under the old law, we need to have those objective measures in place, and you have to be able to show them to the court, to prove them, etc., as we just discussed. So very important, and there's no transitional law between the old law and the new law. There's nothing. So as of April 26, 2019, you have to have those objective measures in place. So that's one thing. And if you don't, then you don't have you don't have protection anymore.
Okay, so just to make that absolutely crystal clear, we can say these measures establish the trade secret.
Yes, it's a prerequisite for having a trade secret in the first place.
Yeah. So what we could say in public and to interested parties is that we say when one thing is for sure, when you don't have any measures which are described in these three aspects by you should never ever assume that there is a trade secret. So the measures makes them, and make sure that these measures are in place to have the prerequisite fulfilled to establish a trade secret.
Absolutely, that's correct.
Okay.
So
because I just insist so, because there is something like it has to be economically relevant, and it has to be it has to be shown that it has a significance, and all these kind of issues. That's also some aspects of know-how and then of trade secrets. But the cornerstone in court is, first of all, these measures.
Yes, I mean, naturally it has to be a secret, so not being published or readily accessible. So this is one prong. But the second and very important one is the objective measures. And then you have the economic value as the third one. And then the German lawmaker, they added a fourth one, which is, it's not in line with the European law, but this is another thing. So it's nothing we should discuss today. But absolutely. So it's very important to have, or it's basically essential for having a secret protection to have those measures in place and being able to prove them. And getting back to your question, so what distinguishes a good trade secret from a bad trade secret? Actually, well, of course, if an information is published, then we don't have to. We have a sudden death here. Yeah. So this is then, of course, we don't have to talk about a secret. And well, it sounds funny, but if you have a product, for example, and the secret is incorporated into this product, and then the product is on the market, then you have the discussion: is the information readily accessible just because it is available on the market? Can you just by looking at it, or by easily readily accessible, accessing it, can you obtain the information? So that in many cases, it is critical and important to look at all the information that was published by the owner about the product and about the information contained into the
Yeah,
product.
we had this discussion in patent law, but I would say that is here a significant difference, because in patent law we had this decision of the enlarged board of appeal that they said that when a chemical compound is out there, it is disclosed even when the somebody who is skilled in the state of the art would not simply be able to reconstruct the molecule on its own. But because it is out, and so it is state of the art. And how is it in trade secrets? So when I do not explain what it is exactly or how you can reproduce it exactly, it is just the molecule or product itself. This I would say you can still say it is a trade secret.
Absolutely, yeah, you're right. So there's a difference between the accessibility under trade secret law and the disclosure under patent law. I mean, you might not obtain a patent because it's not new anymore, but it is still a secret. Another question is, of course, is it accessible by reverse engineering, so that a competitor can legally obtain it by disassembling or analyzing or whatever. This is another thing. The fact that it can be accessed by reverse engineering does not mean that it loses its property as a trade secret.
Okay.
So and so getting back to your question, what makes a good trade secret? What is always nice is or nicer is if you're dealing with manufacturing know-how, which you cannot derive from the product itself. The recipe or the material that you use and all that stuff. So then this is of course more eligible to trade secret protection than an information that is contained in the product itself. And can be accessed.
So the production information can be seen as a separated know-how area, and so how to do it is a difference from you have it in a product.
Yes, absolutely. So
excuse me to disturb you, but there is a question from Amele,
sure.
one of our ambassadors on the IP Business Academy, and I think we have already answered that, but I would like to be absolutely sure.
Thanks, Amel, for this question. In fact, now we do not have a specific standard developed by case law in Germany. So it's a case to case basis, actually. So the question is no, there is no such standard. And how would the measures be relevant for a judge? Well, as I mentioned, if you have adequate measures in place, and then the court would, of course, establish them to be relevant and to give you the trade secret protection.
Okay, and what we said is, Amel, that the logic is that you have to discriminate to secure the access, and this can be done by a proper implementation of access to the file system when the trade secret, the information of the trade secret lies, for example, in form of digital data or files on your file system. So then the typical measures of passwords and access organization to it, that is a logic which can be used, and this is a technology which can be used. So it's not a big thing of encryption or whatever. It is a question of how to make sure that only accredited persons have access. So as Axel said, this need to know, only people who need to know the trade secret have access to it, and proper means, for example, can be implemented with standard Microsoft whatever file system. So I think that is a strong
Yes.
guideline.
And another thing are the the contractual obligations to keep information secret. If you have it in your employees' contracts and supplier contracts, this is also quite important. And this is something this is clearly documented. I mean, you have to be a little bit careful if it comes to employees' contracts. We had just not long ago a decision by the Federal Labor Court here in Germany, which ruled that confidentiality clauses in your contracts with so-called catch-all clauses, meaning that all information across the board is confidential, are not enforceable or not are void. And
so the contract has to be specific.
It has to be specific, otherwise it would be a disproportionate restriction for the employee in terms of his freedom to practice his job, his profession. And so this then you cannot rely on this contract. So be aware and have a look into your contracts, whether the at least the category of the information that has to be kept secret is specified in the contract, and not like everything you ever come across in your while you're working here in this company has to be kept secret. So this is another point. And in fact, that is something that we experience, is that labor courts are stricter in terms of trade secret protection than the ordinary civil courts. It's a funny development, and I hope someday this is going to be streamlined or somehow harmonized. But probably labor courts are more protective towards employees.
Another very specific, but I think extremely interesting question is it's about, again, on your unfortunately I cannot see who is asking that, but I think it is really a point to ask the question, what is with AI in that game? So do you have any experience? So is a trade secret disclosure? I would say from what you said already, it's a clear yes, because once you put it in an AI tool, for example, a description of a production process, and you discussed it with an open AI tool, then the thing is gone, and it will be extremely hard to explain that this was that you took measures, because you don't have any measures once it is a public AI.
Well, yeah, this is actually a tricky question. I think this question heads towards the distinction between readily accessible information, which is no secret at all, or information that can be retrieved or found or developed by something that I would say is a reverse engineering again. So how to draw the line between this, and this is not very easy. I mean, if the information as such is published, then this specific information is no secret anymore. But in fact, what happens in practice is that it's not only a specific information, but a combination of data or information that makes the secret, or the fact that the company and uses this information. Like for example, for their production machines or whatever.
Yeah.
So this makes the secret. So the information itself can be available, and you can find it by asking your AI chatbot. But this does not mean that the fact that the company uses this information is already available. So this is, as I said, this is very difficult
to got you.
tell and to make a general general answer to that.
So the point is, to my understanding now, the point is, what exactly can you do with this information? So is it really a disclosure of your trade secret, or is it just the information, but the trade secret is still there? That could be also so.
Yeah. Just take one of the classic trade secrets is the customer list. A list of customers, or information gathered by all your sales forces outside, and what customer needs what product in the next years, for example. So each single piece of information is available. The names of the customers, where they have the address, the fact that they well, maybe not this information, but however, so the information on when did they purchase the machine and so forth. So each single piece is available, but the fact that all this together makes the list where the company knows, okay, I have to get in touch with this customer next year, because then his machine is 3 years old and he might be interested in a new one. So this establishes the trade secret. So it's not the single piece of information that.
Got you. Okay. Yeah. So we already in the topic of the leak of information. So basically, what is the recommendation, or let's say, what expect courts from companies when they get noticed or get the information that that a leak happened? And is there a time frame? So how do they have to behave then?
Well, I think I would distinguish two scenarios. One is that you need to have a quick injunctive relief. So as a trade secret owner, you discover, oh damn, somebody had access to my information and took it, and now I have to be afraid that they're going to publish it. And then the secret is gone. So the protection is gone. Once it is published, and no matter by whom, it is gone. So then you have to react very swiftly, and try to obtain a preliminary injunction. We just 2 weeks ago we had a case where a former cooperation partner decided to present the product that the two companies developed together on a trade fair, and they announced it, and our client was like shocked, because the moment he does, this former partner does that, the information is gone, and you cannot even apply for a patent anymore. So then we had to go and ask the court to stop that, stop that presentation. So this is one thing, and then there you have to act very, very quickly. The other thing is, if the company observes that there is a data leak, for example, and they do not take any action about it for a long time, this is detrimental to your trade secret protection. This does not mean that in the moment you discover it, you have to act within 48 hours or something to close the leak, or you lose your protection. But you have to do something in an appropriate amount of time to stop that.
Is the next reasonable behavior. I mean, when it is seen as a trade secret and it has an economic value and it is relevant and you do nothing, so why should the court assume that this was anyhow in the first place a trade secret, really?
Yeah. Or if you come across that the password for your login is known to everyone in your company, then you have to do something about it. And if you don't, for quite a time, then the court would say, on the level of have you implemented sufficient secrecy measures, then they would say, okay, no, you did not, so you're out. At this stage.
So Gianluca has an interesting question. He is a participant of the ongoing master program on IP law and management at SAP. Thank you, Gianluca, for the question. So he asked about a training program. So you said there should be a contractual agreement with the employees, and it has to be specific. And we have these technical means. And could that help also to show your will to implement these trade secret regulation?
Yes, Gianluca, thank you very much. Very good question. Yeah, you're absolutely right. Yes, this is one stone in the wall, and this is absolutely a good example of how to show to the court that you have implemented measurements and measures to train your employees, which is, of course, it's not only important for employees that you have already under contract, but also in the onboarding and also in the offboarding process, that you make sure that when a new employee comes from another company, that he doesn't bring poisoned information with him. This is really a threat for a company who doesn't want to violate any competitor's trade secret. But it happens if somebody comes along and wants to shine and brings with him a stick with all the construction details of the competitor's product, something like that.
Yeah, and even when it is implicit, right? So when this guy has no clue, let us assume he has no clue from his older employer that were trade secrets. Yeah. So and then he comes to the next company, and so where is the difference, and where's the borderline between a trade secret and simply my experience? So that has to be crystal clear from both companies, ideally, and to make that sure. And such a training program by HR or whatever could help really to show to the court that the company was not interested in. I mean, I'm hiring because I'm interested in the skills and the experience, but I'm not interested in the trade secret, and that should be documented also ideally to show that
Yes.
when
Yes.
somebody leads you and says you hired him or her because you wanted to get our trade secrets.
Absolutely, because I mean, if as a company you becoming liable for infringement as soon as you get to know that somebody brought a trade secret with him and misappropriated or information that was disclosed without authorization and so forth. As soon as you get to know this, you have to do something, because then you are, as of this, you are liable for trade secret breaches.
Yeah, and the consequences, at least under German law, the consequences of trade secret misappropriation can be brutal and really harmful to the company, because of that the causality here is not so. At least it is discussed whether a causality has to be there or the whole
Yes,
has to
I
be
mean,
there.
and the remedies. I'm sorry, remedies are very strict, and so that this is one of the developments or the game changers of the new law, that now the remedies are IP like. It's like a patent infringement. You can request that that not only that you stop, but that you have to destroy or recall or remove infringing products from the market. And so the moment you come across, you have to do something. So otherwise, the result can be very very harmful.
Or disastrous.
Disastrous.
Yeah.
So make sure that every new employee comes with the knowledge in his head only, and not with something on his data devices.
So we're running out of time a bit. So I ask you for a short answer. But we said now there is a German law, and so how different we have to see that in different European jurisdictions? Can you give us a very short overview on that?
Well, I mean, basically, since we had this European directive on trade secrets, which required all member states to implement at least the same minimal standard, which also which for example is true for the definition of what is a secret in the first place. We should basically have the same level of protection in all EU member states. I cannot say whether this is actually true in practice, whether all member state courts and prosecute infringements as strictly as they do in Germany. What I can say is that there are differences in terms of criminal law prosecution, because of of staffing of the criminal agencies and the workload and all that stuff. But so there's basically the same level of protection, but the way it is enforced is different, I would say.
Okay. Thank you very much. So, ladies and gentlemen, this was too short, that's for sure. But I hope that that Axel will be on our after show party on LinkedIn in the chat and give answers to your questions. I see here a lot of questions, and thank you very much for joining us. When you are a subject matter expert and when you want to cooperate with us, we are still open. And I can tell you, this is the call for 2025, and there will be a call for 2026. This is sure now. It is already fixed and funded. And in addition, when you want to learn more about strategic design protection, so then in 2 days at the 4th of December, we are back. On Thursday this week, we are back with the IP Business Talk, and I will talk with Margot Züller about that topic. Thank you very much to all of you, and thank you very much, Axel, for taking the time and letting us dig a bit deeper into that fascinating field of trade secrets. And this is so important. The importance is rising dramatically because we live in a knowledge economy, and knowledge is key for competitive advantages.
Well, thank you, Alexander. The pleasure and the privilege was mine. Thank you.